Peace and blessings to the family, peace and blessing everybody. All praise is due to the Creator. By whatever name you call upon our Creator, I am thankful that Tamazite Temple University is here. I am thankful to be able to be a catalyst and a communicator for the messages on high and from our ancestors. I am grateful that you are here for this lesson. This is Chief Standing-Elk of Tamazite Temple University. This is the Juris Council class, Proactive Law Class 2. And we will get started right away. So, and this is going to be a great journey. We're going to have a great time, I believe. And I hope we can wake up some minds, and I pray that we wake up some minds. So here we go. This is Juris Council class. This is the second section for students of Tamazite who have passed the point of law apprentice. Then it's Juris Council, and after that is priest of law. We are planning, and I'm excited to say we are planning to be having our graduation August 19th at the Cherokee Supreme Courthouse. The Cherokee Supreme Courthouse. And I will be sending details by email. So be looking forward to that. So this lesson today, we're going to be dealing more on courts and how you are, if you are stuck with dealing with courts, and if you're going to deal with a court, how you ought to move forward with the courts. So we've gone over this, but for some of those who don't know, we have the Black Law Dictionary definition of what is a court. In legislation, it is a legislative assembly. So the legislators can be a court. The meaning of the word has been retained in the titles of some deliberative bodies, such as the General Court of Massachusetts Legislature. So, international law, court would be defined as the person and suite of the sovereign, the place where the sovereign sojourns with his regal retinue, wherever that may be, whatever type of building. And it goes so on and so forth. But we've gone over these definitions. One of the definitions I like to go over for you all to realize is a bottom definition here, where it states that a court may be more particularly described as an organized body with a defined powers, meeting at certain times and places for the hearing and decision of causes and other matters brought before it. Aided in this is proper business by its proper officers. Attorneys and counsel to present and manage the business, clerics, and record and attest its acts and decisions, and ministerial officers to execute its commands and secure due order in these proceedings, in the case of ex parte Gardner. So, court, you see words like ministerial and cleric and counsel. I want you to keep those in mind, because we're going to a point where we're dealing with priest of law. And that's going to be very important for us all. Let's move forward. Court continue. The judge, they also consider the judge, sometimes the judge say, well, the court has made a decision. So in the definition of the court, they also consider the judge or the body of judges presiding over a court. The words court and judge or judges are frequently used in our statutes as synonymous. We'll move forward past this. We don't want to get stuck on all these definitions. But you're getting the point, I believe, of court and its different meanings. I'm going to see if we need anything else. Before we can move forward in teaching you all how to handle our people, whether ecclesiastically or religiously, and whether it's in our religious court body or whether it's in a tribal court body, whatever you're going to learn, whatever you're going to be doing with God's law, when you're going to be doing trust, businesses, and other things you're going to be doing in the world, it is very important that you know how to proceed properly as well as defend the things you have. So this is not just about getting trust, building businesses, protecting assets, or paying insurance to protect your assets, but it's also about you knowing how to spiritually, physically, and legally protect your assets and your family. So it is important for you to pay attention to this class, and I'm telling you, you're going to learn some things from this. A lot of us have been learning to do things the wrong way. We've been hearing from people who don't know or have not won any cases or won any settlements, and they're just doing readings from other places and have not been through these cases. And we need you, before you start handling members of Tamazite, or before we allow you to start handling the people in our name or with us under God, we must be able to see that you can handle these things. So let's go forward. We're talking about court. They described inferior courts is a court whose judgments or decrees can be reviewed or on appeal or writ of error by a higher tribunal, whether the tribunal be the circuit court or Supreme Court. Nugent versus State. It then states the court, as far as courts go, the former being such as are established for the adjudication of controversies between subject and subject, or the ascertainment, enforcement, and redress of private rights. The latter, such as are charged with the administration of the criminal laws and the punishment of wrongs to the public. Equity courts and law courts, the former being such as possess the jurisdiction of a chancellor. So you think of the word chancery court, you think of the word chancellor. That's a court of equity, where you're not asking to collect on the claim, you're asking for a specific jurisdiction or government or corporation to do something in equity of making right the I already used the word right. I was going to say making right the right that was wrong, but that would totally confuse people. So let me see, the better word to use would be putting things back in alignment where there was a deprivation of a right. So it deals with, it's going to deal with rights. So it applies, so the chancellor in the chancery court apply the rules and principles of chancery law and follow the procedures in equity. The latter such as have 110 equitable powers. 110 equitable powers, but administer justice according to the rules and practice of the common law. As to division of courts according to the jurisdiction, see jurisdiction, then they mention many different courts, and this is very important for you all to pay attention to, and I'm going to do some highlighting on that. It's very important because we just go in there flying blind. So you have here RC court, they mention the appellate court, circuit courts, consistory courts, county courts, customary, college bearing, ecclesiastical courts, federal courts, IIIGU commission court, instance court, justice court, judiciary court, maritime court, mayor's court, moot court, municipal court, orphans court, police court, prerogative court, prize court, probate court, superior court, supreme court, and surrogates court. So you see you have so many definitions of court. Let's move forward. This is going to be important as well for you in class. And this is the courtroom. We're looking at a schematic of the courtroom. Because a lot of you have been fortunate enough to have never had to enter a courtroom. Very fortunate. So here you have the judge's bench at the far end of the courtroom. Any judge's associates, possibly in front of a judge here. To this left, witness box. To this right, recording device. It can be vice versa, so don't get so caught up on this one. Right here, court officers, the bar table, what they're called the applicants and solicitors, or applicants and lawyers, solicitors, respondents and solicitors, and lawyers, then a public gallery. Okay, we got that right there. The layout of the courtroom. This is pretty much more well detailed than usual. So here to the right, you have a jury box. So if you walked into the courtroom and you were the red dot, if you follow the red dot, the parties would sit at these two tables here. This would be here on the left of where usually I am as someone who's executing or initiating procedures. Here over here, to the right, is usually your adversarial party. So you have the attorney and what could be the respondent or defendant. Here on the left, you have the petitioner or plaintiff and their attorney. You have here a courtroom deputy clerk who works with the judge. You have here a court reporter. You have a U.S. Marshal if you're in federal court, or sheriff if you're in state court. You have the judge that sits the highest in the court. And you have that's a witness box over here. And you have the jury. So you can see the parts here. So let's count the parts here. You got the adversarial parties. Let's say, I mean, if it's not class action, let's say one party here, one party there. So there's two people in the court, or two, I think we can name the court. On the right side, you have the jury, which is usually the petite jury if it's a trial at this point. So that's 1, 2, 3 positions. You have the attorneys for each. So that's 4 or 5. The witnesses, they play a part in this. Courtroom deputy clerk, 6, who is part of the judge, 7. And the court reporter also is part of the court, 8. And the U.S. Marshal, 9. So you have 9 possible subjective areas of the courtroom, where usually everyone in this courtroom works there mainly every day except for the jury. Only thing coming in and out as the people, or we the people, is yourselves if you're going in and out of those courtrooms. And I want you to remember that. So that means the courtroom deputy clerk here, who works for the judge, see each other all the time. They're there every day. And they're officers of the court. The court reporter, see them every time. She's officer of the court, or he. U.S. Marshal works there. The witness is possibly not going to work there, more than likely. But all these people work together, and then the lawyers are officers of the court. And we'll talk about that coming up in this class. Okay, you have here the court players everywhere. So you got the suit of the ace, king, queen, and jack. We use this because you'll be amazed if you ever studied the historical meaning of the card game. This suit that we're using to show you the court players, the ace, king, queen, and jack in the card game, are actually called a court when they're put together. This is a court. It's a royal court. But make no mistake, it does have something to do with today's courts. But it's not a game. Because if it were a game, it's not a game when you see people going away for a long time, families being split, people being given a governmental death penalty. It's not a game. But some points in time, it's like a game. But it's like the game of life. So, the ace, a spade. Spade would be the highest suit. There's a lot of history behind the spade of the card games. Spade can also, some people say, come from a garden spade. Something used to help till the soil, to plant things firmly in a garden. Some say it came from a tarot suit, and it represents the tree of life. And some say the ace of spades originally represented the death card. So life or death. In that, we have termed that the ace of spades usage for the prosecutor. But the prosecutor in the court is not always an attorney. You have to look at the word prosecution. When you bring in a writ and you are executing the case and you are the one putting the case in, let's just say there is no prosecutor and you put a case in civilly, then it can be argued that you indeed are acting in the office of prosecutor. So you have the prosecutor, a petitioner, a claimant, a plaintiff, and an appellant out of 4 statuses that one can have in a courtroom as far as a court is concerned, of asking if you are the one executing, you filed the case, you executed this, you are the very reason this court is open, because you can open the court on many levels, you can open the court, and we're going to find that out. You the petitioner, if you put a petition in. If you put a claim in, you're the claimant. If you put a complaint in, you're the plaintiff. If you put an appeal, then you're appellant. But if you, and that's when you're proactive. That's when you're proactive. This today lesson is proactive law, not reactive. Reactive law is when you're a defendant or respondent. Here at Thomas I. Temple University, we want you to mainly stay on the proactive side. We can't keep being reactionary forces. You can't keep winning, always being on the receiving end. It's okay to be feminine, though, and sometimes be on the receiving end if you know what you're serving back. However, the masculine energy is the energy that pushes forward. Proactive ways can be masculine or feminine, but here in this situation, I'm going to say it's masculine, and we're going to talk about situations that get you here. So again, the prosecutor is ace of spades, but also we will also use that to state the petitioner, claimant, plaintiff, and appellant can sometimes be a prosecutor. And we'll explain that to you coming up. The prosecutor, an attorney, sometimes an executive branch officer. And I'm talking about the higher prosecutor who come from the elected. Prosecutors are usually from a state's attorney's office. You can have a county state's attorney, well, you can have a county attorney who they somehow say is a state's attorney, but we'll get into that later. But the usual is a prosecutor that's elected or selected is an attorney. They work for the executive branch of government. How would you know that? Usually state's attorney's office officials and county attorneys have a badge, as the same badge as any other executive office, such as police officers, marshals, some parts of the IRS police, state police, and state police. So if you know any state's attorney, you actually ask them, say, can I see your badge? They have a badge. They work for the executive branch. This is going to be important to you to understand these different offices because it tells you their scope and authority. And it is very, executive branch is a very masculine branch because again, we talk about feminine energy as an energy that takes in, pulls in. And masculine energy is energy that pushes out. And that executive branch, the main word is execute. They're going to have to get things done. They're pushing, pushing, pushing. So be mindful of that. When somebody from the executive branch is calling you in and they're trying to talk to you about something very nice, like well, I'm from the state's attorney's office, I'm from this, and you didn't call them to do anything for you. Usually they do masculine energy work. So you can figure that one out. But it's usually the higher selected elected prosecutor is an attorney from the executive branch, has a badge, is elected or is selected by the person that's elected, has an oath of office, has a bond, and has a rule of professional standards. We talk about this ACE, y'all, in this court card. Next, in the courtroom, we want to talk about the king of Spain, judges, whose jobs are to interpret the law and referee controversy. Judges, you can usually find information on them in the Federal Judiciary Act, right here on your left, and the judicial canon, and the qualifications for a judge are usually through election at the state level. Federal judges are actually chosen by whoever you vote to be president. And we're going to talk about this voting thing as well, because the presidential election is an election, So voting is a democratic thing for a democratic business. You're supposed to be electing, which should make you an elector, and not voting, which makes you a voter. But in order to be an elector, they do want to be registered to vote, to put these judges in office. You're going to see the power of the judge at the local level and at the federal level. But the federal level, you have less power over judges because they're chosen by the president and the presidents before them, depending on how long they have had. The judge has an oath of office, has a bond, and they work for the judicial branch of government. Remember, we said the prosecutor works for the executive branch. Even though they are empowered by the judicial branch, their work is more executive. The state constitution judiciary act is another one to check in on the judge. And judicial canon, we will go further into that at Priest of Law, and you will actually read what the judges' professional standards are and what they're taught to do in what's called judicial canon. The Queen of Spades would be the judges' clerks. Clerks of the courts, court reporters, and they all work for the judicial branch of government. So that's what we will look at as the Queen of Spades in this royal court. Again, remember these cards, we talk about these face cards, are called the court. They're the royal court. So the queen of a courtroom would be the judge's clerks, which are their deputy clerks, and they belong more to the judge than they are assigned to the whole of the court, as in the administrative clerks who work with the administrative clerks. All the clerks should be working totally under the if it's a state or county level, it's an elected clerk. And all these people should be in this queen suit are the people who make the court work, who make the job of the judge easier. And that would be the judges have their own clerks. So when you have a case, you make a case, and you think that the opinion is coming back, the opinion of the law and what it actually means and how it should be utilized in your situation is just done by a judge. Before the judge sees these things, sometimes their clerk looks at your case, puts their opinion on it, sends their opinion to the judge or a magistrate or all together, sends to the judge, and the judge then makes the opinion based off of their opinion. So sometimes you got to know who you're talking to around that court. And again, this is the judicial branch employees who work for the judge. So the queen, the king is the judge in this suit, and the queen would be not under the judge, but this queen would be the feminine energy, the wifely energy that makes it easy for this man or this masculine position of judge to go to work. Makes it easy for this masculine position of prosecutor to do its work. These positions, these clerks of the court, judges, deputy clerks, court reporters, they make these things easier for them. So I want you to look at this. The jack, the wild jack, the jack of spades. The jack used to be a wild card. The jack used to also be represented as a knight card. And the knights of the courtroom would be attorneys, lawyers, counselors, assistants of counsel, which all work for the legislative branch of government. Why legislative? They are given their powers by the judicial branch of government. The Supreme Court is usually the actual court that gives attorneys their right to practice at law. You have a lot of gurus that teach that it's this bar, or it's the American Bar Association, the Illinois Bar Association. No, it's not them. And it's not the universities or the law schools either. When you learn to research and read law, you will learn that attorneys, lawyers, counselors, which we will describe and talk about the three differences in those three definitions in the next class, because that's going to be very important to you. They have a job similar to the judge. They're not the ultimate authority on interpreting law for anything. They are there to assist you. And I'm not talking about the attorney that is a prosecutor. Talk about the attorney that's there with you if you hire one. And here at Preside, we don't have anything against hiring attorneys as assistants of counsel, as long as you put them in their proper office, because that's the constitutional right, and we will discuss that again in next class. I just want to show you the players in this, because once you know the players, you know how to maneuver. Also on this jack, which used to be a knight, and you know the function of a knight, these are the soldiers. These are the people that make it happen outside of the court. These are the actual ones that go to war, if need be. These are the wielders of the sword, or the word, or the orders. So these others, we talked about the attorneys in the jack, but now we want to talk about the other part of the jack, which is the knight. It's the old jack, which would be a knight. The executive branch of government, which would be the sheriff and marshals. It would be a sheriff or a sheriff deputy at the county level of a court, which is linked into the state level by funding as well as contracts. The sheriff and sheriff deputies. Now, in the federal level, it would be the United States Marshals. These are the knights of this court. But these knights of this court, you have one elected sheriff for each county. Anybody under the elected sheriff should be a deputy. So when you call all these deputy sheriff, yes, they're in the office of service of sheriff, which comes from the Arab, which is similar to the Arab word sharif, keeper of law and order. For God, this sheriff, however, is not working for any God that we know. And then the U.S. Marshals are different. I've never seen a U.S. Marshal election, and since we don't see federal judge elections, I can figure out why, and one can figure out why. Federal judges are, again, chosen by the President of the United States in this United States. So, of course, you have the U.S. Marshals, but still, they should still work for the executive branch of government because they execute. They have an oath of office. They have a bond so that they can work. And if they get sued, that bond is supposed to be utilized as in place of their assets. Again, but the sheriff is elected in the state or in the county level. And they all enforce court orders of the judges. So they are the executioners, the knights of the court. They're the ones that go out and find you for a summons or subpoena. They're the ones go out, and if they find you at a bench warrant directly from the judge, they can come out and get you. And it's not just the judge that can send them out, because we got other players coming in, y'all. We gotta watch all the players. Right now, this is the players' ball. This court is the players' ball. So next we got the little joker. The little joker is an interesting character that came up. Any joker are interesting characters that came up in the history of playing cards. And this is a thing for the court because the little joker, for this purposes of this class, is being shown to be the petite jury who decides the fact of a case. Trial jury is another nickname for them. This is a French thing. The little joker, petite jury, little jury, petite, little jury. So this petite jury works like a little joker because in the end of all the results, in the end of the facts, this petite jury is the people in office. If they're not elected, there is a selection process for them, but this is supposed to be we the people. This is we the people's chance to interact in the court and try to bring balance to the judicial branch, the executive branch, and the legislative branch of government, which is all in the courtroom. We would think that the entirety of the courtroom, everyone in there is the judicial branch. Yes, it's a judicial branch run thing, but every branch of government is right there in the court. And everything is at play, and these games are being played. The way to stop a game, either way it go, is God or the people, because God resides in the people. So this is a chance for the people to make decisions in the court. Because, again, the little joker, the little jury, the petite jury decides the facts of the case of a trial. So the judge, remember, the judge's job is to decide the law. How does this law fit and interpret the law in the controversy? The trial jury actually is aiming at the facts of the case. So when you write a case and you write down those facts, or you make an affidavit of facts, what you want that for is when you have a jury trial, because no one else can tell you the facts because they were not witnesses, they were not there. The lawyer, the prosecutor, the court reporter, none of them was there of whatever the controversy is. They were not there. You are the master of the facts. And the people who decide the fact that you master is the petite jury or a trial jury. I want you to remember that. Here we have the big joker. The joker seems like a jester or a joker, and I believe that this symbol is very close to the trickster. Some people call the devil. That's a trickster in different religious circles. And it could be a trickster because it's a very tricky situation. The big joker is also said to have a history with the tarot card called the Fool card or the Fool's card. But here, for the purpose, it represents the grand jury. So we read the report on the grand jury Preside, and we want to discuss this in class. You'll be able to ask questions by email, via email, and I hope that you do. So send me an email if you have any questions, comments, concerns. TamaziTemple@gmail.com, class. For any questions, comments, concerns on this presentation, and thank you for sticking with this presentation. Not going to be long. So the big joker, the Fool's card, or the Fool card as well, the grand jury. Why is that? Because it could be so powerful that it trumps everybody, or it could be so weak that it's used to trump everybody on another end. But it's very important, because the grand jury is we the people as well. The grand jury, let's discuss the grand jury. The grand jury Preside reading that we talked about and that you have basically mentions that the grand jury is empowered by the 9th and 10th Amendments to the United States Constitution. And the 9th and 10th Amendment says that powers that are not used by the government, but the federal or state, belongs to the people respectively. So read the 9th and 10th Amendments and realize that this is the power of the people in the courtroom. And it's a very powerful thing, this grand jury. The grand jury's power was to check the prosecutorial power. We read in the grand jury Preside where it stated that the prosecutor has now kidnapped the grand jury, whereas the grand jury started out as we the people and to check to the powers and make sure that prosecutors that don't run rampant and just make up crimes they want to make up as they've been doing to the people. And the people come in the courtroom as grand jury and they can stop this, but they don't know their power. So here from this video, I want you to know, grand jury, your power. The prosecutor is not over the grand jury. It should not, but the prosecutors have now taken a hold of the grand jury. And we're going to talk about more of that later. In the grand jury room, when we read the grand jury Preside reading, attorneys for defense are not allowed around in a grand jury proceeding. They have to stand outside the grand jury proceeding. And you get to go, if you are ever summoned to a grand jury proceeding, you have an attorney that's for your defense. You have to go outside. You have to ask for a break from the stand to ask to go outside and say, hey, I can't talk to my attorney. Grand jury indictments and grand jury meetings are held in secret. Grand juries are said to be able to subpoena without Fourth Amendment privacy protection. Pretty much, if they subpoena you, you have to come answer. Or they could send a warrant out and arrest you for contempt of court. And they can actually keep you arrested and in jail as long as that grand jury is going to be performing their duties as grand jury, even if it's 6 months. So I want you to be mindful of that. The grand jury can bring indictments on government officials as well, though. And this is why I say they're powerful. But because they wait for prosecutors to bring them crimes, the prosecutor is pretty much in charge of what comes in front of them. And the prosecutor, of course, is not about to bring in some crooked official. Sometimes they do, sometimes they don't. I'm interested to find out if the ex-governor of Illinois, Rod Blagojevich, was brought in front of the court on these charges through a prosecutor to a grand jury. I'm interested to find that out. But let's keep going. The grand jury is not supervised by a judge. Once they're in session, they're not supervised by a judge. So the only one in the court with the grand jury is the prosecutor. What do you know, right? Grand jury members must be registered voters with a driver's license. And we'll get into that coming up. If you read the Jury Act of your state, your Jury Act of your state would tell you how juries are selected. It would tell you who selects the jury. It would tell you the jurisdiction of a jury, and it would tell you the qualifications of one to be on the jury. Grand jury reform is being spoken about right now, as I am a member of the American Bar Association, the ABA. They have grand jury reform principles. They're trying to save the grand jury and return it back to its power. And the ABA have pushed that, according to the American Bar Association, as it says, the grand jury has come under increasing criticism for being a mere rubber stamp for the prosecution without adequate procedural safeguards. Critics argue that the grand jury has largely lost its historic role as an independent bulwark protecting citizens from unfounded accusations by the government. The question of fairness in grand jury proceedings has thus become an issue of special interest to the legal profession. But it's been an issue to the people. Over the years, the ABA has developed 31 specific principles to restore the grand jury's original protective function and to eliminate abuses in the grand jury system. These American Bar Association supported principles include allowing counsel in the grand jury room, requiring the prosecutor to present exculpatory evidence to the grand jury, and granting the targets the right to testify. So in the grand jury, it's like a witch hunt at this point. The prosecutor has brought in front of the people the side they want to believe, saying that you did something, you're guilty. You can't come in there and defend yourself or have witnesses that can say that you didn't do it. Once the prosecutor gets a hold of something and they think that we can make a crime out of this, we can make some bonds off of this, we can make some money for this court, for this state, for this county. It's like vampires. They got you in their fangs and they're not letting you go because you at this point in time are bait and food. So I can't applaud the American Bar Association for its jury reform principles. And if you want to see more on this, you can Google it or go to the ABA website. I have the American Bar Association magazine that comes. So, and they have an online magazine that comes to you if you're a member. And we're going to look into more of this, what they'll say about the grand jury. But I want you to look at this most important thing about this. When you're looking for indictments to come to these cops that kill what people are called Negroes, Black people, African Americans, and Latinos at will, and other indigenous people, it is the grand jury, we the people, that get fooled by the prosecutor into not doing enough to get convictions on probably hidden, secret, invisible empire Klansmen masquerading out as police in your community, killing your people. So getting a hold of this grand jury, getting it reformed, is a big step to changing it. So the rest of the grand jury reform of the ABA goes so far forth to say that it is worth noting that this problem already arises with efforts to enforce existing rules. Today, a suspect who believes that the prosecutor has violated the grand jury rule can seek access to the transcript of the grand jury, but typically a court will require a preliminary showing of the violation before ordering disclosure. Suspects are thus in the difficult position of being unable to claim a violation without knowing what occurred in the grand jury room, but cannot discover what occurred without first claiming a violation. So reforms that fail to address the tension between the government's interest in secrecy and the suspect's need for evidence to support a claim will simply compound the problem. So for those that think about challenging the grand jury in some of the cases that you have. They're bringing these things up. Even proposals. Well, you know what? We'll talk about this more in depth later. I'm going to the next part. Recognize the limits of the institution of the grand jury. Some of the concerns about grand juries may be the product of unrealistic expectations. Reform proposals often seem based on the assumption that if grand juries were just given more evidence, or if prosecutors had a bit less influence over the proceedings, then the jurors then would be able to effectively screen the government's charging decisions. This belief is probably unfounded. Well, this is what this person says, nephew. So I don't want to cloud your head on that. I do believe that if more evidence can be put in there, if more sides can be heard, then there can be better and greater justice for all. The barriers to a grand jury's ability to screen cases are not obvious, they're saying. I'm not even going to read the rest of this. I put it up here, but we'll go through that. You can read it as it sits on the screen, or if you go back over the tape, or if you rewind. But I'll go to the last part here, where it says, in submitting a case to the grand jury, we are asking non-lawyers with no experience in weighing evidence to decide whether a legal test is satisfied, and to do so after the only lawyer in the room, which is the prosecutor, has concluded that it has been satisfied. Because jurors lack any expertise in making this assessment, it becomes not only predictable but also logical that they will return a true bill in nearly every case. Not because they are rubber stamped, but because they have no benchmark against which to evaluate the evidence, and thus no basis for rejecting the government's recommendation to indict a person. So you can see how powerful this is. This grand jury is very powerful. It is the office of we the people. It's not elected. It's not, there is a selection process. It's supposed to be the office of the people. However, it's been kidnapped and subjected. And right now, the ABA and other organizations are fighting to get it back, as well as we the people. There are people out here, such as myself, who have sued in question of this thing happening. So if anyone here gets a chance to be on a grand jury and you are hearing this, join that grand jury and do the right thing. And do not let the prosecutor tell you what to do. Look at the law and learn to read the law, and you will know your function. Because at that time, you are more powerful than the prosecutor. Because you can actually bring them up on charges. Grand jury versus petite jury, which is a trial jury. Point can be made more easily by comparing the role of grand jurors to that of trial jurors. It might be argued that trial jurors make a similar sufficiency of the evidence decision when they decide whether the prosecution has proved this case beyond a reasonable doubt. But in fact, a grand jury determination of probable cause is qualitatively different than the trial jury's verdict. And these differences are crucial to the ability or inability of the two panels to perform their respective functions. So there's one justification for having lay citizens serve on a trial jury is that we believe, this is the ABA speaking, that non-lawyers are at least as good as judges at weighing the facts and deciding which of the competing versions of the case is correct. Indeed, the adversary system is based on the idea of presenting two biased versions of the same event and letting a neutral decision maker decide where the truth lies. So, this is just contrasting the grand jury to petite jury. One, the grand jury is looking at the beginning of a case before it becomes a case. Before this case is born. The grand jury is a parent, sort of a case. It's the mother of a case. The grand jury can either produce offspring, which becomes this long case that goes to trial and meets the petite jury, or can slam it because there was no probable cause or reasonable suspicion for the crime to be a crime. But a prosecutor and the police officers can together work the story to the way that they know it's going to become a crime. And we've seen these things. So there needs to be reform on the grand jury. It's very powerful because anyone can be brought on charge of the grand jury. And to throw some of my college education in for your usage, my people. And I'm thankful I was allowed to go to college and learn that side of things directly from the oppressor. The grand jury were also the people who revolted and took over France during the French Revolution. The grand jury took upon itself the power to prosecute government officials who were killing France as a nation and killing its people. They took it over. The grand jury is that powerful that it can change an entire country and society. Let Illinois show you how. I want you to do your homework. Go to your state and look up your statewide grand jury act. 725 Illinois Code of Statute 215-1, 2, and beyond. 725 ILCS 215 states that a county grand jury or county grand juries and state's attorneys have always had and shall continue to have primary responsibility for investigating, indicting, and prosecuting persons who violate the criminal laws of the state of Illinois. This source, Illinois Jury Act, www.ilga.gov, and so on and so forth. You can see it on the screen. Then you can go to it. This is just Illinois. You are for homework to look into your own state and read your state's Grand Jury Act. Illinois Grand Jury Act continuing. Written application for the appointment of a circuit judge to convene and preside over a statewide grand jury. So the question is posed, who chooses, in Illinois, who chooses the Illinois grand jury? 725 ILCS 215 section 3 states, there's a written application for the appointment of a circuit judge to convene and preside over a statewide grand jury. So someone applies with jurisdiction extending throughout the entire state shall be made to the Chief Justice of the Supreme Court. So there has to be an application that goes to the Chief Justice of the Supreme Court. So the highest court in your state, there has to be an application stating we would like a grand jury. Upon such written application, the Chief Justice of the Supreme Court shall appoint a circuit judge from the circuit where the statewide grand jury is being sought to be convened, who shall make a determination that the convening of a statewide grand jury is necessary. So the Supreme Court Chief Judge receives an application, but from whom? 725 ILCS 215 Section 3, who authorizes the Illinois grand jury, or who's writing this application to the Chief Judge of the Supreme Court in demand of a grand jury of the people to be convened? Well, Section 3 states, written application for the appointment of a circuit judge to convene and preside over a statewide grand jury with jurisdiction extending. Hold on, did I read this? Okay. Written application for the appointment of a circuit judge to convene and preside over a statewide grand jury with jurisdiction extending throughout the state shall be made to the Chief Justice of the Supreme Court. Upon such written application, the Chief Justice of the Supreme Court shall appoint a circuit judge from the circuit where the statewide grand jury is being sought, who shall make determination that the convening of a statewide grand jury is necessary. In such application, the Attorney General shall state that the convening of a statewide grand jury is necessary because of an alleged offense or offenses set forth in this section involving more than one county of the state and identifying any such offense alleged. And it continues. So I want you to stop and see that the Attorney General of a state is the one who applies to the Chief Judge of the Supreme Court to have a convening of the grand jury, to do the investigative thing and to cause the execution of charges, or what's called indictment in a true bill. What do you know? So now you know when cases come down wet route, because the Attorney General is elected in the state. So you really had the power to put in your own agent that can choose the proper grand jury members or jury of peers in an area to serve true justice for the oppressed. So, qualifications for someone to be in a state grand jury, or qualifications for a state to have a grand jury, I apologize. Upon written application, let me see where it goes. Upon written application by the Attorney General for the convening. So after the Attorney General writes the application to the Chief Judge of the Supreme Court for the convening of an additional statewide grand jury, the Chief Justice of that Supreme Court shall appoint a circuit judge from the circuit for which the additional statewide grand jury is sought. So if it's Brooklyn County, you know, I don't know the counties in New York, I'm just saying. If it's Philly County, if it's Cook County, then that's where they're going to say, okay, that grand jury is going to be right there in Cook County. The circuit would be that county, usually. The circuit judge shall determine the necessity for an additional statewide grand jury in accordance with the provisions of this section. No more than 2 statewide grand juries may be impaneled at any time. So there you have 2 grand juries can be at one time throughout the state. So you're saying this grand jury is moving from there's only 2 grand juries at a time that can move across the entire state of so many counties? Okay. How are they serving justice there? They seem to be overwhelmed. The Attorney General or his assistant shall attend each statewide grand jury. Which right now, that's Lisa Madigan in Illinois. So the Attorney General or his assistant shall attend each statewide grand jury and shall prosecute any indictment returned by it, unless the state's attorney of the country or county of venue for the indictment consents to prosecute the indictment. That's interesting. So the state's attorney is just, unless the state's attorney of the county of venue for the indictment consents to prosecute the indictment themselves without the grand jury, which is something, we'll get into that later. The Attorney General or his or her assistant shall have the same powers and duties in relation to a statewide grand jury that a state's attorney has in relation to a county grand jury. So the statewide grand jury is run and chosen and dealt with by your elected Attorney General. And this is going to come into, and we're going to get to a lot of conversation, because in this life, in this world of gurus, in this world of what's so-called conscious community, you are told to abandon your post, to denationalize yourself with this country, with the area you may have grown up in, and things of that nature. You're told to do that. When you do that thing, look at what you cannot do. You cannot elect a fair Attorney General who can help apply for an actual grand jury of justice, who can actually make a difference and make a change. That's not what we're getting from that. So you got people telling you to not vote, change the voting rights, tell them you don't want your voting card, you don't want your driver's license, you want this, you want that. And that's fine if that's what you want to do. But then you cannot state that I was dragged into their court and I could not get justice, because if all of you all leave that, and any of us can get dragged into their jurisdiction somehow and can't get out, then now what have we done? What have I done? 705, Illinois Code of Statute 305.1. The county board of each county, except those counties which have a jury administrator or jury commissioners, as provided in the Jury Commission Act. So this is the Jury Commission Act, shall at time or before the time of the meeting in September in each year, or at any time thereafter, when necessary for the purpose of this act, make a list of legal voters. List of legal voters and the Illinois driver's license list and the Illinois identification card list, an Illinois person with disability identity card list, and the claimants for unemployment insurance of the county, giving the place and residence of each name of the list to be known as the jury list. So again, the jury list is made out of those who are legal voters, registered, those who have an Illinois driver's license in Illinois, or an Illinois ID card, or Illinois people with disability identification card, or those who have claimed unemployment insurance, are those who can be on the jury list. And the list shall be made by choosing every 10th name on that list or other whole number rate necessary to obtain the number required. From the latest voter registration and driver's license, Illinois identification card, Illinois persons with disability identification card holders, and claimants of unemployment. So the latest list that they have in September, up to September, they're going to choose every 10th person on their list to be on the petite jury. And I'm taking it for the county, for a county, and a grand jury for a county. So you want to know how you're chosen? If your names are on the IDs for the state, driver's license, if you're taking unemployment insurance, or if you have a disability card in Illinois. So you ought to read again for your homework your state's Grand Jury Act and see what theirs is. But the status of citizen is what you need to have, and the things of a citizen to enact and to affect and to be on a jury, which is a grand jury or petite jury, to exact any change in justice if you so desire. So that was that. So I had a question for you that I asked earlier. If one denationalizes or unregisters to vote and has no license, then can they serve on the grand jury? So if you believe in the East Coast dudes, gurus, the internet gurus, and you say you got your status paperwork, you take yourself out of all of that, you get rid of your driver's license, no birth certificate, and everything. And someone who looks like you, who may be indigenous like you, is dragged to that court somehow and they can't get out. Will they have you to save them? Because you can't be chosen for a grand jury, in which you would have the power at that point to bring up charges against all kinds of government officials who do crooked things to the people and to make actual change. You wouldn't be able to vote for the judges in your area who can actually make decisions to change things. You wouldn't be able to do election. You wouldn't be able to become an elector. And that's fine if it's what you want, because this class is not to convince you of what to do. But this class is to open your minds and your eyes as to what's being said to you and what you're doing when you're following these people with this denationalization paperwork and renationalizing into a tribe that doesn't exist, or renationalizing into a religion that thinks it's a nation, or renationalizing into someone who doesn't have land, who does not have shelter for you, who cannot provide health insurance for you, who cannot provide social help for you, things of that nature. That's your choice. So at the September meeting of any county board in Illinois, they're going, and September's coming up, they're going to choose this jury. What they look for in this jury is that this jury is full of people who are inhabitants of the county, who are of the age of 18 or over, who are free from all legal exception, of fair character, of approved integrity, of sound judgment, well-informed, and able to understand the English language, whether in spoken or written form, or interpreted in sign language. And they must be citizens of the United States of America. That is the county jury qualifications. Continue. After the juries are selected, they shall be kept in the office of the county clerk. So at the county level, your county clerk is also elected, actually has the names and residencies of each person selected to be on the jury. So if you ever want to contest a jury's indictment and to challenge it, there are so many things to challenge. Were they from the county? Did they actually live in the county? How do you know they were of good character? They have made up crimes against people like Sovereign King Bey in the courts, and he's actually challenged the jury indictment, but they would not let him get anywhere with that. But you have to know the keepers of the jury list. At the county level, it would be the county clerk. I believe at the federal level, it would be the court clerk of the Supreme Court. But we'll double check that again and go back over that. So, 705 Illinois Code, Statute 305-16, a full panel of the grand jury shall consist of 16 persons, 12 of whom shall be sufficient to constitute a grand jury. So 16, we usually think it was 12 and 12, so you can see it's 4 alternates and 12. After the grand jury is impaneled, it shall be the duty of the court to appoint a foreman. So the court in which is at appoints the foreman. So if it's there at the Supreme Court and with the chief judge and the attorney general who is the highest attorney in the land and is elected, I would believe this would state that either the appointed judge of the chief judge, someone they appointed, or the chief judge would appoint the foreman for the grand jury. And the foreman's job, the foreman shall have the power to swear or affirm witnesses to testify before the grand jury, and also the foreman's duty, his or her, shall be when the grand jury or any 9 of them find a bill of indictment to be supported by good and sufficient evidence, that foreman will endorse the bill. So that foreman's signature will be on the bill of an indictment, making it a true bill, and a sworn and subscribed signature, stating it has witnesses, they swear by it, and has an oath to it. Well, they do not find the bill to be supported by sufficient evidence, though, that foreman will say this is not a true bill, and shall in either case sign his name as foreman at the foot of the said endorsement, and shall also, in each case in which a true bill shall be returned into the court as aforesaid, note thereon the name or names of the witnesses upon whose evidence the same shall be found, or shall have been found. So can you see all this power? Imagine if you were ever a foreman of a grand jury. You're writing the bills that's bringing up the crimes around. So if you were the foreman of a grand jury or just a member of the grand jury, and you knew that in your midst, trying to be a witness, was also a police officer who was just said to have killed Castile or Gardner or anyone, and you can turn and say, I have unlimited subpoena power and unlimited questioning power while you're here, so I want to ask you some questions, and I want to put a true bill and sign a true bill against you. Do you not understand the power? I wish I could play that, I got the power, but I ain't got that right now. So, in all that, in the bottom of this, I would say, stop dodging jury service. Stop dodging jury service. Stop dodging jury service if you want justice for your people. Let us continue on. Now, in civil cases, upon impanelment of the jury in any civil case now pending or hereafter commenced in any court in this state, Illinois, again, you need to read your own state's jury act. It shall be the duty of the court upon request of either party to the suit or upon its own motion to order its full number of jurors into the jury box before either party shall be required to examine any of the jurors touching their qualifications and to try any such causes as provided. So this would be the grand jury. I believe we are an hour in. And so I am going to end this recording with that, with your understanding of the grand jury. And there's going to be a part 2 to this recording coming right behind it. Please do the homework of reading your jury act of your state, and we will have discussions on the grand jury facade reading, and I am thankful again that you are here. I'm thankful to be presenting this energy. Please reconsider and look at what you do when you change up where you're going because of some guru. You have to be able to afford to be free. If you're not going to be free and you just think you're disappearing out of some system and you get wrapped up in it, or someone you know that's in this same movement get wrapped up in it, think again. You could have been of more help as a member of a grand or petite jury. See the power. That is the power of we the people. That is your power to do things. That's your power to make a change. Stop dodging jury service. Tamazight Temple University, Chief Standing-Elk. We are signing off. In God we trust. In God we trust. In God we trust. Peace.